on our people. And so on the Constitutional Court, let me put the matter to rest in that way. Because there's none more competent in debating this issue than the present speaker. At least not in this House. Maybe outside of it. So when I speak on these matters, I speak ex cathedra. I speak with the authority of the office of advocate, not president now, advocate of the courts of this republic, and constitutional lawyer and scholar, having published also on human rights and the Constitution. So the point I was making is, let us, Relucas, in relation to the SONA ki di bone. Ebile ke a di lebogela ka gore o no o itebagantse le go beta ditharabollo. Re ka tswa re sa dumalane ka tsone, re ka tswa re dumalane. Mme ke go lebogele gore wena
Excellency, can I have clarification on question?
wa itebaganya le ditharabollo.
Clarification, Honorable Dr. Obotswang.
Mr. Speaker, Mr. President, o ka tswela setšhoma Sekgowa le Selatini le Seroma. Boammaaruri ke gore the horse has bolted. O setse le tsene mo dikganyeng tsa go baakanya molaomotheo wa rona. Mme o sa tsamaye le rona. Setse o ra lona le goromente, lona le goromente. Where are the people? Ha ele gore le batla go tsamaisa yalo, Mr. President, you must expect a pushback. I'm warning you. I thank you.
You've been pushing back. You've been pushing back. Nothing is being pushed. You've been pushing back, brother. And I'm one who never shies away from a pushback. I push. That's what intellectualization is about. It's a marketplace of ideas, isn't it? So it doesn't freak me out that people are threatening to push. I want people to push so that I can also push back. That's why I've said, beware the power of the bounce back, because sometimes it causes a blowout. You push and you blow yourself out. It's dangerous sometimes.
Clarification, Mr. Speaker.
The point is this. Yeah, let me make the point so that you can comment on something that...
Clarification, Mr. Speaker.
No, wait. Come on. No, please give me a bit of time, comrade. I want to engage Relucas in relation to a proposition I know he holds dear. I was explaining the distinction between negative rights, those that are prohibitive, that preclude the government from doing certain things. And I gave the example of Section 5. There's also Section 10, the Fifth Amendment in the United States, the right against self-incrimination. And when I gave the example of circumstances when you may be arrested, and I said there are only 3. In a case here, interest David Tawele, member of the BCP, Judge Mosojani said, to assume you can arrest in order to investigate is a dangerous misunderstanding of the law. Interest David Tawele, Judge Mosojani, you investigate, then you arrest. You don't run an arrest and say we're investigating. And you arrest on a reasonable suspicion in relation to the 3 circumstances I've outlined. This is the rule of law, as it should be understood. Now, I'm getting to the second generation rights, and I said these impose a positive obligation. These now have resource implications. They instruct. Embedded in them is a consideration of budgetary outlays. You must provide work. You must provide this. You must provide that. Where does the power to determine the utilization of public funds lie? It lies with Parliament to the extent that those funds accrue to the consolidated fund. And how do the courts treat a situation where somebody, and before I get to that, how the courts treat it, let me also make this point that a right entrenched in the Constitution is not a privilege. And I could take the whole day jurisprudential and break down, there's something called the Hofieldian scheme, where you have rights, no rights, privileges, jural correlatives. I could break it down. It's a whole concept. It's a diagram. It's intense. Jurisprudence, that's what it is. But a right is not a privilege. A right is justiciable, meaning you should be able to go to court and enforce your right. You should be able to sue the government and say, the Constitution affords me a right to work. I'm unemployed, and I'm availing myself to work. The government is not hiring me. So I want the court to pronounce and protect my right as enshrined in the Constitution. That's justiciability. That is why Uduetse Munanyana could go to court, because his rights which were violated, negative rights, are justiciable. Now, let us examine the justiciability of second and third generation rights. What do you say? What is the answer? And the law says this. The law. Impossibility of performance is a defense. That's the law, brother.
Clarification. Clarification.
There's a court order here. Wait, let me make the point. The interjections must also be timed so that the point is made. They are useful that way and helpful. If there's a, Lucas, if there's a court order and you fail to obey the court order, you can go to court when they drag you there and say, it was impossible for me to comply with this order. And you demonstrate to the court. And that's a defense. It's an absolute defense. Now, if you seek justiciability under a second or third generation right, and you go to court, and the executive, which is the holder of the purse, says, there are no resources, there's no money. It is therefore impossible to hire him. That's an absolute defense. How then do you deal with this? You've entrenched it there. In other instances, the court does this. It issues what is called a structural interdict. A structural interdict is where the court engages with government and says, how long do you think it will take you to mobilize the resources? And the executive can say, give us 5 years, reviewable. It takes you 5 years. You haven't gotten employed. You may have even expended resources to go to court to seek to enforce a questionably justiciable right. Jan, Botat, Joneju. The court takes the approach of a structural interdict, which is not helpful. This is what happened in an American case called Brown versus Board of Education of Topeka in relation to a concept in a separate but equal education facilities. Others arguing for it. Equal does not mean same. Equal. Equal means and for a number of years they were given time by the court, and black children were being bused to some of these schools as part of the enforcement. That's a structural interdict. Now, the structural interdict route is a very uncertain route, and that is the difficulty that it will present in relation to the justiciability of second and third generation rights. Gary, re talk gore ha re o hetola motheo re tlhaloganye gore me maparego, what are the constraints that will water down the right that we purport to entrench, so that it does not just exist in the textual formulation of a new constitution, It must be a right capable of enjoyment by the ordinary person and enforcement. If it is not, then we create a problem in addition to, and we would have hoodwinked the masses into believing that we are solving the problem. We would have failed. These are some of the issues that will arise in the context of a constitutional education process.
Clarification. Clarification.
Clarification
on our finish. Mr. Speaker, Mr. President, ke tsa ke re gongwe khanye ya molao motheo o itotile thata tota kana ne ke utwa ba go kganela o santse o re tsena mo go etsa botsogo eno ke tlwaele tsebe thata ka gore ke khanye bothokwa thata yone maloba ke go a khotse thata ga ke respond to sona ka go bulela sepatela sa se Ketumile gore se nne public yana gona le confusion tautona mo nako ya gompieno ye batho ba sa tlhaloganye gore a sepatela se public se tshwana le sa Marina le Nyangagwe ka gore as we speak gore batho ba ntse ba duela gompieno ga re ba teka di medical aid gore ba bone thuso yana ne ke batla gore gongwe yone o e papamatse hela motswana a tlhaloganye ko gae gore a ska a go busiwa kwa a tsa gore gongwe go tshwana le ko Marina kana ko Nyangagwe se santse se operate hela ya ka sepatela se private.
Further clarification.
Further clarification?
Yeah. Clarification over Hikwama.
Yeah, me ke a leboga Mr. Speaker ke lebogela nako ya gago Mr. President. Ke setse ga ke dumele gore o tla lebala jury a ke a lebala putso ya teng. Ke go busetse ko go ya constitution le ditshwanelo. Gona le kgang ya ibuegang Mr. President. Ya gore re na le batho ba ba tholetsweng leso ba ile gore ba emetse go kalediwa go ya ka wena o e ba emisitse wa riska ga kaletswa ope a mme go ga gona le boamaruri gore ba emisitse a mme le molaone wa re a mme o ka emisa hela go sena se sa shorilwe se tšhaba le di court le mongwe le mongwe gore a itse gore go diragala eng America tshelela mo gore go pateletse president o emisitse me go sena se ka se supa gore go emise president. What is the law says gone ha motho a kalediwe me o batla go busetsa ko morago.
Mr. President,
makisimo le ka ya botsogo ke re kana go bona ditsamaiso tse potso e re ne ra e botsa ke gore na sepatela se sa agilwe ka ditsompelo tsa gama tsa puso se ke se patela mohuta mang ga se ka ga tlhatswega gore is it private or public mme go bona la gore it certainly isn't public ke bona ra bore tsa tshwetso gore se patela se anong se hetolo ene public facility a public hospital jaaka go ne go ntse go ra gore ditsamaiso tsa gore go diragala ha ngwe go na le bangwe ha gare ha ba ba kgonang go khopetsa ka mabaka a gore ditsamaiso tse ne di le teng ngwene di ba thusa ebile di ba berekela yeo ke kgang re tla itebaganyang le yone ke gore se ke se tlhalositseng ke batla ke se tlhalose gone ga gompieno ke rile dikgwedi tsa ntlha tse 12 were predominantly learning leveraging while leading ha re tsamayang teng the slightest misalignment with what has been pronounced in the interest of the people, I can tell you, results in removal. Because now it is for cause. We don't care what you say. If you want to go to court, you'll go to court. We'll face you in the courts. But what we are not going to do is to sacrifice the lives of our people because certain bureaucratic machineries are aligned and arrayed against what we want to do. And I think there's something of that sort here. But it will be attended to. So that hospital. mme gone go mo ga go kgoreletsa diemo tse e leng gore di ka thusa batho ba rona re gorogile ga e le gore ga di sa tlhodi amogelesega. It is not tolerable. And so le tabolelela gape le re ke o koba batho mo ditirong. Comrades, I must tell everybody, every citizen of this country, anybody whose conduct at the workplace or anywhere else impedes rendering assistance to our people, that person is surplus, is not needed in the system. And where we are, the guillotine is hovering. You know the problem with the sword of Damocles? There's a Damoclean overhang. It's hanging. That's what it means. Janu, the death penalty situation. The president has not made any pronouncement regarding the death penalty. And I gave an illustration recently. I went to represent the University of Botswana in a moot court competition in Zimbabwe. I met the judge in the panel where I appeared was Johan Kriegler, who was a judge of the Constitutional Court of South Africa. I had lunch with him after that because he was exceptionally impressed. So I talked to him. And I had occasion to speak with him again when I was an observer for the International Bar Association and the treason trial of Morgan Tsvangirai. I had occasion to sit with Johan Kriegler again. He was an observer for the Johannesburg Bar. He had now retired from the Constitutional Court. He said to me, I'm a believer in the death penalty. That's him. I looked at him and said, no, that's not true. He says, no, I am a believer. I believe in the death penalty. I said, no, you are not telling me the truth. I know you sat in the death penalty case, State versus Makwanyan, Mkunu, and others. You said, I read your judgment. You pronounced against the death penalty in that judgment. And Johan Kriegler said to me, yeah, you're correct. You see, in that judgment, I was interpreting the Constitution of South Africa, not my own personal biases, beliefs, and predilections. I personally, away from the Constitution, am a believer in the death penalty. But I could not impose my own views on that sacred document that I was interpreting. Now, let's separate personal preferences from what the law directs. What does the law of this country direct? It directs a number of things. I want to deal on the trot with some of them. The first is this. After the Court of Appeal seals somebody's fate and pronounces death, finally, that person has only one recourse. And it is to the President under the prerogative of mercy, Section 53 of the Constitution. Then the President must make a determination. There's something else, though, and it is this. The trial judge, in other words, not the judge of the Court of Appeal, but the High Court judge who initially sentenced this person to death, must write a confidential report to the President about this sentence of death. And when I practiced as a lawyer, as an advocate, I sought to challenge this. And I said, it is a denial of justice if there can be a confidential report given to the President relating to a person who's seeking clemency from the same President, and this person is denied access to this document, and only the President sees this document. Where is the fairness? So let's interrogate the process itself first. Where is the fairness? And the overarching human rights and constitutional principle is it must be fair. And the fairness must run from trial all through sentencing to the last minute. So is there fairness where there's some information withheld from this person? So I remember petitioning the office of the President then and demanding to be given access to that document. And it wasn't given. That's the first thing that arises in relation to the death penalty. The second is this, and I'll give you a live illustration. A guy, a Masire man, born in servitude to parents who were herding other people's cattle. At 10 years old, this kid is given to a different cattle post to go and herd cattle there. He goes, separated from his family, never has any contact with them. He's a Masire for all we care, isn't it? He goes and he grows up there, dislocated from family, no support system. He's the maid here, he's the head boy, he's everything. This kid grows, and at a certain level, and throughout, his only coping mechanism is what? Is the foggy dose of daga and alcohol. That's what keeps him. He works, grows, reaches a level where he meets a lady. They fall in love, maybe. I don't know whether they fell in love. They consorted as lovers. He had a child with this woman. Now, this is his family, isn't it? He looks after the child as best he can. Still lives his life, foggy dose of daga and alcohol, but looks after his child and this woman. One fateful day, the woman looks at him and says, I don't want you anymore, and I don't want you to ever come anywhere near my child. This is his child. Cut off, thrown out. He leaves, goes far to a different cattle post. That's all he knows. Lives there, herds cattle, falls in love with another woman. Now this one has her own child, and they beget another one, his. Looks after them. And same thing. One day this woman comes and says, I don't want you. I don't want to see you. I don't want you anywhere near. What happens to this kid, this young man? You are a social worker. Yes, I am. Yeah. Now I want you to wear your professional hat and imagine what happens in the mind of this young man. He remembers the trauma, the unglossed ferocity of the treatment he had received. He picks up a bar, hits the woman. She falls and she dies, and looks at the child who's standing there and kills the child too. And the woman was carrying his child on her back. All the three died. It went to Francistown. This man was given the death penalty on all of them. It went to the Court of Appeal. I had the invidious assignment of dealing with this matter. I went to see the guy. I looked at his circumstances, his background, everything, and I realized one thing. He had been poorly, shoddily represented by the lawyer who was assigned, a prodeo lawyer. Because most of the guys who get sentenced to death are represented by prodeo counsel, who are not paid enough for anything at all. So this kid, the lawyer went to consult with him the day before trial. Trial begins. The lawyer hasn't informed himself sufficiently, pursued a wrong approach to the case, and sinks this guy. So that child was convicted by the lawyer as well. See? And then I went to the Court of Appeal representing this kid. I was constrained by the evidence that was there. The approach the lawyer took was wrong, bad, ineffective legal representation. Caused the death of that young man. And I wrestled with the Court of Appeal. I got him off on the two, the mother and the child on the back. I got him off on those. The Court of Appeal looked at me in relation to the child who was then said, but Mr. Boko, how about this one? I had a very difficult assignment. Difficult to try and get him out. They confirmed the death in relation to that not the two, the three. Now it was one death penalty, still death. He goes to prison. I went to my office and drafted papers. I wanted to challenge ineffective legal representation. I wanted to raise certain other issues. I also wanted to challenge the process by which this man could not be given access to the report from the court. But what happens? I go to the prison to have him sign an affidavit. I'm told the guy is not here. Some prison officer. He's not here. Where is he? No, he's gone to Ramoswa for an ear infection. I said, no, but I'll follow him there. He says, no. Come here tomorrow morning at 8, he'll be here. This chap, the prison warder who's telling me this, knows, and that was unbeknown to me, that they had read the warrant for the death of this man. So they were preventing access so they could kill him. So on my way to the prison, as I had engaged with this guy, before 8 o'clock, an attorney at my office, he's now Deputy Permanent Secretary in the Ministry of Trade, he calls me. He says, our client has been executed at 4 o'clock or 5 o'clock this morning. Imagine the trauma. I get there, I see the same guy, I say to him, brother, you told me to come at 8. I'm here. It's before 8. And my client has been hanged. The guy couldn't say anything. I had vowed that when I took office as president, and that was many years ago, and I knew I was going to stand here, I said I would find this guy and do something to him. But I haven't, you know. So that's why sometimes I say I'm a wounded healer. I'm wounded. And here's this wounded man who has to deal with death penalty cases, who understands the injustice inherent in this, who knows how lawyers sometimes misrepresent, don't apply themselves because they are not paid. You see, and they get hanged. Come on now. How does one deal with this? And you accuse the president, he's sitting one. Now, there's another dimension. If you kill a person here and you flee to South Africa, South Africa will not surrender you to Botswana unless Botswana gives an assurance, and the president must give that assurance that this person will not be hanged. Otherwise, under South African constitutional law, they can't render that person. They can't extradite, even though there's an extradition arrangement. Meaning, if I translate it into the simplest, a person who kills and crosses the border escapes death. One who kills and stays here will die. Where's the fairness? There are about 11 people in South Africa. And there's a judgment from the South African court in the case of Zebe, where the court in South Africa came down hard, criticized the Botswana government for this matter. So you have a disparity here, a disproportionality of result, where the one who kills and stays dies. The one who kills and flees lives. How do we explain this? What if the person who is now facing death comes and says, no, I'm being treated differentially. There's differential treatment, which is a violation of Section 15 of the Constitution.